Hello, everyone. We're just going to let people flow in for a second, and then we'll get started. Hello, and welcome to IP Pitfalls to Avoid When Fundraising. I'm Julie Cranston, Director of the SBDC at UCI Beall Applied Innovation, and I'd like to thank you so much for joining us today. Today's webinar is brought to you by the SBDC at UCI Beall Applied Innovation in partnership with Wilson Sonsini. The SBDC is funded in part by the U.S. Small Business Administration and the state of California. The SBDC is here to help you start, grow, and succeed in your business by providing no-cost expert consulting and training such as this webinar. In addition to our regular consulting on business management and equity funding, we also have been helping our small business clients understand and apply for SBA loans like the Economic Injury Disaster Loan or EIDL program, and also the Paycheck Protection Program or PPP loan. We can also advise on how to administer these loans if you receive them, so make sure to reach out to us if you need assistance. We have a hotline set up and additional resources available. The hotline number is 1-800-616-7232. We'll put this number in the chat. If you're a tech or life science business, you can go straight to our intake form at sbdctech.org/contact. We also have a COVID-19 resource guide available at ociesmallbusiness.org. We'll put all of this information in the chat feature. A little housekeeping before we begin. Everyone is muted during the webinar. Tomorrow, the recorded webinar and a PDF copy of the slides will be sent to all participants. There will be Q&A at the end of the presentation, but please feel free to ask questions during the webinar by clicking on the Q&A box at the bottom of your screen. We may not get to everyone's questions, but we will do our best. If we don't get to your question, please email hkhaled@fullerton.edu, and we will attempt to answer your question and get back to you. Our program today will be moderated by Matt Bresnahan, partner at Wilson Sonsini. Matt's training is in all aspects of intellectual property, including strategic patent counseling, patent prosecution, licensing, and litigation. Matt is primary outside IP counsel to more than 60 life science companies within the pharmaceutical, molecular biology, diagnostic, and medical device fields in Southern California. A significant number of Matt's clients are life science spin-out companies from one or more of the major universities, hospitals, and research institutions in Southern California. He prosecutes patent applications before the USPTO and manages and oversees national and international patent portfolios for his clients. Matt has analyzed intellectual property portfolios and performed IP due diligence for venture capital firms and other investors and businesses in a variety of investment environments, including financings, mergers and acquisitions, and initial public offerings. Sara Pennebaker will join as well, and she's an associate in the San Diego office of Wilson Sonsini. Her practice focuses on patent prosecution and intellectual property counseling, serving clients in a wide range of technology fields, including the pharmaceutical and biotechnology industries. Matt and Sara, thank you so much for being here and for your partnership in presenting this event. I will now turn the program over to you to introduce our panelists today.
Okay. All right, so here's the agenda for today. We'll introduce our panelists. So thank you, panelists, for joining us. I'm going to allow you to introduce yourselves, but just for the attendees' benefit, we have Kathy Koo, Chief Licensing Advisor at WSGR, David Cuccia, who is the CTO and President of Modulim Imaging, Inc., Casie Kelly, who's the Assistant Director at Invention Transfer Group, UCI Beall Applied Innovation, and David Friedman, who seems to be involved in every organization, business consultant at SBDC at UCI Beall Applied Innovation, and President of our TCA. Kathy?
Hi, I'm Kathy Koo. I've been at Wilson for about a year and a half, but previous to Wilson, I ran the Stanford Office of Technology Licensing for about 27 years. So I'm very steeped in university industry relations. And now on the Wilson side, I'm trying to help startups bridge that gap and bring the technology into their companies.
David?
Hi, I'm David Cuccia, CTO of Modulim, and I helped build this company out of a tech incubator at the University of California, Irvine, specifically at the Beckman Laser Institute, where we invented a method to see tissue health that informs on lots of things, including helping diabetic patients avoid complications like ulcers and amputations. So we're currently bringing our first product to market and have a lot of experience working with the university licensing, filing our own IP, and can talk to any of those kinds of trials and tribulations one goes through as they're building a company.
Yeah, hi, this is David Friedman. I'm a former tech executive. Over the last 12 years, I've been with Tech Coast Angels and recently took over as Tech Coast Angels Orange County president. I've been involved in the angel community for a while, and this is really pertinent since we always want to try to find companies that have a defensible moat, and IP is just one of those various vectors to do that.
Hi, I'm Casie Kelly. I'm Assistant Director of Licensing at UCI Beall Applied Innovation. I've been at UCI for over 8 years now, and I manage a portfolio of life science inventions. My background's in microbiology. Before I was at UCI, I was at UCLA's Tech Transfer Office for about 6 years. So I'm happy to be on this panel and look forward to speaking with you all.
Thank you. Okay, so I'm going to quickly run through the pitfalls. It'll be a bit of a countdown and provide a little bit of context for some of the things that we'll be talking about today. We will be accepting any questions or comments that attendees might have in the comments function. So please feel free to do that. I'll be moderating that aspect as soon as the panel discussion begins. So as soon as I wrap up, I'm going to pass it off to Matt. Okay, so number 6, not complying with Beall. The Beall Act it was a U.S. law passed in 1980 that provides incentives for federally funded inventions. So if you're a startup company that receives federal funding in the form of an SBIR grant or a research grant, this would apply to you. You have certain obligations to notify the government when you develop certain inventions and file patent applications covering those inventions. And failure to do so can create a situation in which the federal government could restrict or even eliminate your ownership in that IP. So for at least this reason, this compliance with Beall is something that investors are concerned about, or at least interested in about. And increasingly, we see it as a material fact that needs to be disclosed in any IP diligence call. Failing to understand the scope of your patent rights. So the scope of your patent rights is determined by the scope of the claims in your patent. Generally speaking, one issued patent, so say you're a startup company with one issued patent, congratulations, that's fantastic, but you don't want to stop there. It's important to consider how your competitors might design around your issued claims or how your commercial product might evolve over time. So plan on filing continuing or new patent applications to build a perimeter of exclusion for your commercial product. And be prepared to discuss your general IP strategy to investors, including patent protection for your commercial product in the key markets of interest. Prematurely publishing inventions. So in most countries, prior publication of an invention can preclude your ability to obtain patent protection for that invention in that country. And in this context, when I say publication, it really can mean anything. A poster presentation, journal articles, talks, symposia, prototype demonstrations, you name it. And although this impacts all startups, definitely, it's particularly relevant for spin-outs of universities or research institutions just due to the incentives in academia to publish inventions. So, take care to prevent publication of your inventions by the company or its collaborators without first having filed adequate patent protection. All right, number 3, obtaining a license agreement or an option agreement that investors will not like. So we see this a lot. Many early stage startups seek a license or some sort of option to license IP, at least at the very beginning. And the terms of that initial license agreement or option is critical for ensuring that the company can actually spin out. So our panelists with tons of experience in this area are going to touch on a lot of these pitfalls, but just to name a few: limitations on assignment of the license agreement or sub-licensing, such as what is most common that we see, requiring university consent before you can do so. Avoiding impossible diligence milestones that are going to increase your likelihood of breaching the agreement. And then economics in general that just don't line up with your commercial strategies. So royalty stacking and thinking about payment of royalties to multiple parties to commercialize your product, or if you're commercializing a kit, considering a combination products language in the license agreement and so forth. So our panelists will dive into that. Failing to control your IP rights. This is a big one, and it's relevant really to all of these pitfalls. So control of your IP rights can mean ownership, and it can mean making sure that you have all your exclusive licensed rights tied up in your IP. But the bottom line is you want to ensure that your startup company has all the rights to its IP that you think it does. And number 1, last but not least, conducting insufficient IP diligence. So for any major transaction, there will be IP diligence. And there are a couple different components to that our panelists are definitely going to expand on. But one of them is having a coherent IP strategy. So thinking about inventorship of your IP, subject matter of your claims, and the regions with which you have patent protection are just a couple of examples. Another is making sure that you have all the rights that you need from your collaborators and your university partners in order to commercialize your technology. And the last and probably the most important, at least for larger transactions, is going to be making sure that you understand the landscape of third-party IP. That, you know, understanding the risk that to the extent you do commercialize your product, you may infringe a third-party patent. So we call that freedom to operate. Okay, I'm going to pass it off to Matt. I know that was a lot of information quickly. We'll be taking questions.
Great, thanks, Sara. And yeah, let's leave that slide up. So why don't we explore each of the topics that Sara really did a great job of introducing and summarizing. We have a great panel here. So let's jump into it. First question on maybe we can just go in order on compliance with Beall. And Casie Cuccia, as she mentioned, has tremendous experience in the university licensing context, and at Wilson Sonsini, we're thrilled to have her on our team. Very lucky to bring her in at key times to help our clients understand some of these very nuanced issues. So why don't we start with you, Casie, on Beall, and can you speak to the importance of why complying with Beall is really critical to a startup company's success?
So I feel like complying with Beall, if your invention is funded by the federal government, is one of the most important things that you can do. And honestly, it's a little bit of a pain, but you have to do it. The government has all sorts of rules and regulations on what one needs to do. And the first and foremost thing you need to do is disclose to the government that you have an invention. And then you usually want to choose to file a patent on it, and you have to let them know. Now, if you're the recipient, you have the obligation. But if you're taking a license from a university, the university has the obligation to comply with Beall. So we want to make sure that the university has also complied with Beall, done the things that they're supposed to do in order to make sure that you do have, that the university has title, or that you, the company, has title. If you don't do it properly, there can be a real cloud on the rights that you have. So it's a very, very important thing to do. And it's one of those housekeeping items that if you don't do it carefully, if you don't comply with Beall, you put your IP at risk.
Great. Thank you, Kathy. And as a follow-up there, are there any resources that are available to founders, PIs, investors that might be interested in learning more about Beall compliance?
Well, Wilson offers an FAQ for our clients on how to comply. There's all sorts of information on the web. There is a whole Beall iEdison. There's a whole system called iEdison that enables one to comply with Beall. It's a little bit kludgy, and the government is trying to make it better. There are also other consultants. There are a few companies who will help small companies comply if they don't want to set up their own system.
Great. And one last follow-up. Mentioned some of the implications of commercializing an invention that was funded, at least initially, with federal funding. Can you talk a little bit about margin rights and why or why not an investor should be concerned if they see in a university license that the government has certain rights to the inventions licensed in this license agreement?
The government under Beall has a right to march in on an invention if the invention is not being developed by the licensee. So in general, if a licensee, if a company just sits on the technology, the government can come in and take it away, basically. Now, in this day of COVID and drug pricing issues, there is talk about the government marching in to prevent the price of drugs being so high, for example, or there is talk about marching in on remdesivir. But the reality is the margin right is supposed to be exercised only when a company is not developing the technology, just sitting on it. But again, if you don't comply with Beall, no, they could march in. The reality is the government hasn't done that. There isn't, I don't feel, a real worry, but it is something to be concerned about and to be aware of.
Yeah, sure. And if they didn't do it in the midst of this pandemic, I'm not sure what circumstances they would.
Yeah.
Great. Thank you, Kathy. And we'll come back to you on some additional topics here shortly. David Friedman, and I'll be clear to use last name since we have two Davids here today. As part of your diligence process from an investor's perspective, why is Beall compliance important to you?
Well, I think, sorry, I think Kathy really hit the nail on the head, but let me give you a little different context, because I think this will make it clear from a broader perspective on what we investors look at. We look at the issue of what is unique, what is defensible. And when you break that down and you look at what Beall has to say, we want to make sure there's ownership, control of ownership, and obviously no margin rights. So we have to be able to do something. But it all gets down to the central key message. We want to make sure that when we invest, the people who have that patent own it, control it. We don't want to see that all of a sudden a former partner has rights that can sort of eliminate that defensibility and that unique position.
Perfect. Very well put. Thank you, David. And we'll come back to you as well shortly here on some additional topics. Let's turn to, in the interest of time, I'll keep this moving. Topic number 5 here that my colleague Sara introduced. Another pitfall here, failing to understand the scope of patent rights. Casie, great to see you again. I'd like to turn to you, and maybe you could, with the topic of failing to understand scope of rights, and in your experience working with a lot of startups out of UCI, what are some of the common misunderstandings that startups have about their in-licensed patent rights?
Right. So, some problematic situation I've seen is when the startup isn't particularly clear about the patent rights. They might not have worked through how does this IP really fit into the product that I want to develop. So, for example, they might have not done a thorough freedom to operate search, or they might not you know, they might not appreciate the difference between a composition of matter claim or, you know, a method claim. And I also, you know, have seen where the startup company doesn't have a good understanding of where in the process are the patents or the patent application that they are licensing. So is it, you know, are we at the provisional stage? Are we at the PCT stage? Have we gone through national phase? And what, you know, what do all of those things mean? And so this is obviously an issue if, you know, you're not prepared for your fundraising, if you don't know this sort of information about the patent portfolio you're licensing. But, you know, it can waste time and waste money and leave the startup sort of unprepared for what's to come, like what decisions they need to make about the IP. So, you know, when we're licensing, we try to educate our startups about all of these issues, but we really recommend that the startup have someone on their team who is very knowledgeable about intellectual property and getting that advice.
Great, makes sense. And I take it you've seen firsthand not having a clear understanding of the scope of IP having a negative impact on the ability to raise even a note or safe financing.
Right, yeah, definitely. If the investor can see that the startup doesn't understand the issues about their IP, then they're going to pass on the investment.
Excellent. And nice segue back to David Friedman. You talked a little bit already about what you as an investor are on the lookout for from an IP perspective. How can a startup best prepare for an IP diligence call that you might schedule with them prior to making an investment decision?
Yeah, so let's take a look at IP and let's go beyond what we normally consider IP, that is patents. Because intellectual property to us means a lot more. It could be, and I'll explain it in a second, it could be patents, it could be copyrights, it could be trademarks, it could be social media, ownership of URLs, social media, ownership of your Instagram account, your LinkedIn account, whatever else. And then finally, it's trade secrets. A lot of the software companies don't publish, for example, the patents on their software. When I was at Norris, which is in cybersecurity, we had a huge portfolio and we had a strategy to publish all of our algorithms so we can protect it. But others of smaller companies may not want to do that. So when we want people to prepare, when we prepare for doing due diligence, we'll look at each of these categories. And the issue is control, ownership, and of course, use. We don't want something like a URL, which has, you know, is an asset of value. We don't want that to go fallow and let it just sit there without being used. Somebody else can, you know, claim jump it, so to speak. So again, when we look at something, look at IP being these variety of things that control. This goes back to the original point, you know, defensibility, uniqueness, sustainability. It all comes down to that basic core element, and anything to do with IP and its extension thereof has to do with those three elements.
Excellent. And all ways that you can protect the competitive advantage with a barrier to entry is what I think you're getting at, which is a great point. It's not just one particular type of IP, but how everything fits together. Great.
Matt, I have a question from the attendees, if you don't mind interrupting.
Yeah, that'd be great, Sarah.
So it relates to Beall. And the question is, if you have an idea for a patent and then you secure SBIR funding, are you disadvantaged by Beall?
This
So
is
you have a patent filed before, just to be clear, before the grant is obtained?
Well, the question is, you have an idea for a patent.
Got it.
the language.
Okay,
For
Casie.
The language for Beall is usually conceived or reduced to practice. So even if you conceive before the grant, but you reduce to practice under the grant, it would fall under Beall. Beall in itself is not a bad thing to have apply to your invention as long as you comply with all those obligations.
Great. And a good segue to topic 4 as well, in that generally speaking, once a grant, aside from Beall and even particular types of grants, but once a grant is funded, it can become available by a Freedom of Information Act request, so it can become prior art. So let's talk a little bit about topic 4, a huge pitfall, especially in the context of spinning out a university-created technology. We see this all the time, of a publication, unfortunately, coming out prior to a patent filing being made. And as Sara correctly mentioned, a publication isn't just a journal article publication. It could be something as simple as a talk that is not under strict confidentiality, or a poster presentation at a symposia, an abstract that comes out prior online before a formal publication occurs. So very much a strict requirement, and something that we should be thinking about. So we've heard from licensing officer guru extraordinaire in both Casie and Casie, as well as the investor's perspective. I think it would be good to turn to the company perspective. And we have David Cuccia with us, and David, I understand, is the founder of Modulim. David, maybe you could share a little bit about Modulim and how the company spun out of UCI, and any experiences you have in creating an IP strategy that keeps in mind the goal of avoiding premature publications before you can make those important company filings.
Sure. Well, I think to start, I'd say I was a graduate student at UC Irvine and an undergrad before that, Zot. And I was very fortunate to learn about patents and the importance of filing from UCI's OTA at the time, and Alvin Verrey is our case officer, and it still is to this day. And so he taught me how to write a patent and how to file one and the things to be concerned about. And so that was a good exposure, and kind of being immersed in that kind of environment has been grown by applied innovation is really important. If you don't have local access to something quite on that scale, still try to immerse yourself as an entrepreneur in all these types of events so you can learn the language and learn what to think about. So if you're here, you're doing the right thing already. We had a number of cases come up where we were concerned about things getting published too soon. I think as a general principle, what we learned is that it's just important to have good relationships and manage people's expectations and manage them up front. So one of the first things that was important when we founded the company, I was still a student, but we were already applying for SBIR grants for the commercialization. And when we did win one, I became the PI of that after I finished my PhD. Is that we created explicit interaction contracts with the university. We said, we created a template that says, anything that the company does in the room that they're renting is paid for by the company, and therefore can be the company's exclusive IP if we were the only inventors. Anything exclusively invented by a university faculty even involved in this project would be exclusively owned by them, and anything jointly invented would be jointly owned. And I think that was the first step. And then when you create this research contract, there's a couple of different flavors depending on if it's sponsored research where the company's putting up money, or if it's more of a investigator-driven research. But in either case, you'll have some sort of term of expectations about what kind of grace period you can agree upon, that where the company would be given sufficient time to file before something related to the project is disclosed. And kind of managing those things up front, having good relationships with the faculty members and the graduate students that are involved, perhaps, if you're a university-based startup, is the best way to combat that, because people will give you a heads up if they see something coming and they understand what your concerns might be. And then diligence on the company's part to do what they've signed up for and make sure that the things are filed on time and that the right inventors are recognized and all of that. On that note, as an aside, we've had one case at least where there were joint inventorship. And so both the company and the university had full rights to use and license that technology. And yet still, even in that case, we decided to license exclusively the university's component of it so that we could have exclusive access worldwide to that. So those were the kinds of things I think about. We haven't had, thankfully yet, knock on wood, haven't had any big issues about that. The one place that is a little bit on the gray area, and this might be in the noise, but for us, we were heavily involved in the research and all of the grant proposal aspects of the institute we were part of. We would participate in demonstrations to people that were coming and doing a site visit, for example. And those were the areas that we were particularly careful to either not say something that was still not yet filed, or be explicit about the fact that this was private information and this is being conveyed to you under the expectation that this is a confidential grant review that you're performing. So those are the areas I think that are important to watch out for. Excellent, great points. And I'm not surprised that you haven't had any issues, because clearly you all have created a great IP strategy, and frankly, not something we always see until there is an issue of having that coordination with the PI and their group. That's really great to hear, and the planning on ownership that you laid out. So that's great to hear. Any comments from the team at this point? Any other panelists? Lots of great points are made.
Yeah, I'll just mention, Matt, I can just mention that, once there's a startup involved, the PI is generally, working with the startup pretty closely if they're not, they're probably a founder. And so a lot of times we hear about new IP through the startup. And so it's sort of a group effort to make sure that we're on top.
Can't forget about you guys, right?
But it's a good thing. I mean, obviously the inventors are very excited about what they're doing. And so it's all, it's all good all around. But I guess I'm saying is a lot of times the startups are concerned about, future publications. And again, it's usually, a lot of times it's the startup that knows first. And so we just all have to keep in communication, and we've not had, we haven't had an issue like, as David has said, it's possible to not have, big issues.
Yeah, that's great. The coordination is key in, having the regular meetings. And staying with you, Casie, so we talked a little bit about a more mature company once the base license is executed, and then the company spins out, and there may be some continued collaboration on joint IP. Maybe the company has its own IP. Maybe let's take another scenario of just an entirely new opportunity. For purposes of the benefit of faculty members and PIs, could you explain a little bit of just the general process that UCI has in place to try to get in front of publications that could happen to allow the opportunity for you all to file the patent before that publication happens?
Yeah, I mean, obviously a lot of our outreach is geared towards informing inventors of the importance of filing before publishing. It doesn't always work, but it's just a constant education piece of ours. The other thing to be aware of, and some faculty members don't appreciate, is that we can file pretty quickly. And so, the process of getting a patent application on file is not going to slow down, the publication of a paper or stop you from going to a meeting. So sometimes people don't want to deal with it because they think we're going to tell them no or something, but that's not the case. We're here to enable them, and but to also protect the intellectual property.
Great, perfect. So I think that's a good segue to point number 3, right? So now we have the patent that's properly filed prior to any publication that may have occurred after the filing. Should the PIs, for example, choose to do that. Let's talk a little bit about how we go about efficiently obtaining a license or option that investors will see as adequate for the stage of the company. And so maybe staying with you, Casie, at UCI, could you explain, with the understanding that there maybe is no typical arrangement, but what are some of the common ways that companies looking to commercialize UCI IP go about, maybe from the beginning of any type of letter to the final license? Can you maybe walk us through that process?
Right, sure. So if we have a startup company that's being formed around some technology, most of the time we are entering into a letter of intent or an option agreement first. And those agreements are generally giving the company a lock on the technology for a certain period of time and allowing them the opportunity to go and seek funding, because in general, what we want to see is that the company is, maybe getting close to closing a financing round, as they're entering into the final license agreement. So the option agreement, we can do things that may help them in front of an investor, such as, negotiating a term sheet that's attached to the option agreement, so that the company, we can quickly pivot to the final license agreement, once they're getting close to closing, to finishing a round of fundraising.
Great. That's maybe short of undertaking the full time and expense of a full license, right?
Right.
Yeah.
Exactly. Because, the way, different schools do it differently. The way we structure, our options and LOIs is to make it, very, cost efficient, and to delay past patent costs until a full license. And so that's why the companies generally want to stay in those agreements until they've made a lot of traction with investors.
Perfect. Perfect. And one little nuance there too, you could consider accelerating a patent, right? And if you're able to get it issued with the company paying in that option period, that might be something that investors might be more interested in too than otherwise. Before all the time and expense of the full license.
Right.
Awesome.
Right. True.
Cool. Yeah. Thank you, Casie. And Kathy, maybe turning to you now that we've understand maybe some general pathways to go down to obtaining a license to university IP. What are some of the major sticking points that you've seen in your experience on both sides, at many years at Stanford and now working more on the company side, that you might be able to provide some guidance on, just generally, that if we're resolved in a more fair way, would help avoid situations where the company might have to go back and renegotiate things with the university?
Well, it's always an interesting situation because at the beginning of the relationship, which is sort of the license or the option, you predict what's going to happen in the future. And the reality is the future rarely turns out exactly like that. So what each side is trying to do is come up with an agreement that matches their expectations. One of the things that I've learned, from being at Wilson and seeing the other side is that sublicensing, especially in the life sciences, is a really, really big issue for startup companies. Clearly, life sciences companies will partner with bigger companies. That's sort of the model, the VC model. And if they have constraints on what they can do with the sublicensing, then it really creates usually an issue for the company. So basically, I think a startup company would like to be able to sublicense a big company, maybe big pharma. Big pharma may also have their own partners that they're dealing with. And so typically a university will allow a company to sublicense once, but it would really be good if that big pharma can sublicense to their partners too. So again, startup at the very beginning of their path should try to get us the right to sublicense as broadly as possible. Now, I understand from the university side is they don't want to lose control of who has rights under certain patents. And so the university will try to control a little bit. The other thing is, again, if for some reason the original license agreement with the startup company is terminated, then the sublicenses should still be in effect if they're necessary for the future, for the further companies to practice the invention. So again, from a startup company side, if the license expires or is terminated, the sublicense should still survive and go back to the university in general. The other thing that I really, really advise startups is to come up with very realistic diligence milestones and make sure that they're very clear that they can make them. Because we've had instances where the licensee has to go back to the university and modify the diligence milestones. If you give the university plenty of time and you've been in touch with the university and have had a good relationship, they'll probably not be surprised if there's some potential miss in the diligence, but don't wait till the last minute to try to modify those milestones. Keep talking to the university so that they understand where you're coming from, and in fact that you're still trying to diligently develop the technology. I mean, as Casie will say, the most important thing for a university is to have a licensee develop the technology. And if the startup can show that they are still developing the technology and there were challenges on the way that were unforeseen, then I know the university will work with the startup company. But it's hard to go back and try to renegotiate that in a lurch. So try to think ahead and maintain a good relationship.
Great, great. And then generally, a couple more points. What were your thoughts on royalty stacking and combination product type provisions, and how are those concepts different?
So this comes into play mostly when you're thinking ahead about your actual product that you're going to sell. So it also gets into the whole IP diligence. Is there freedom to operate? Are you going to have to pay royalties to several parties in order to get that product on the marketplace? And so royalty stacking is a good clause. You want to be able to say, okay, well, if I have to pay many parties some royalty for IP rights, then I'm able to reduce the royalty due to, one party so that I can pay a maximum of X percentage on the whole product. And it's sort of divvied up among the various IP owners. So that's what royalty stacking is about. On combination products, it's if you have two, let's say, active ingredients in a kit or in a therapy, that if you have two drugs that you're going to deliver at the same time, that you can actually break them up and you pay a percentage to the one party that owns IP rights for the one thing, and you can not pay on the whole product, but only on the portion that is owed to the owner of that IP.
Excellent, thank you. I think those concepts are folks can get tripped up and confused between them. So that's very helpful. And obviously trying to find middle ground there early on can help expedite things. David Cuccia, let's turn back to you if you could. Could you just share a little bit of your experience about how critical it was to have a sound license agreement at the earliest stages of when you went out to raise money?
It was always an important thing to have in place whenever we were speaking with investors. Even the earliest angel investors we spoke to wanted to know that we had access to the IP. And we secured a letter agreement like Casie mentioned. And we were fortunate to have a lot of flexibility given to us from UCI's OTA. So we extended that letter agreement a number of times actually, and then entered into negotiating the full license, which I think ended up taking 1.5 years. I think that's probably atypical, but there were times where the university was slow. There was time where we drug our heels. But again, as long as everyone's expectations are being managed, I think it can work out fine. And that has been very valuable. We were able to, for us, negotiate an exclusive right to all 4 patents that we had invented at the university in all fields of use with a sublicensing clause that was flexible. And it has worked out well, and it has lived well. So that agreement has evolved where there have been new cases from the lab that we came from that were, kind of corner cases of uses of the technology that might not have been covered under the foundational IP. And we just, rolled that into the existing license. So as long as we agreed to, and I hope that's okay to disclose, as long as we agreed to
Yeah,
continue paying for the maintenance of those patents, it was included as part of the deal.
As an amendment,
Which
is common. Yeah. If it's an improvement upon what, the platform IP, for example, it just makes sense.
That's right. The one thing we were never able to negotiate at the time, which would have been even better, would be any right to first right of refusal for new IP coming out of a specific domain. And haven't been able to crack that nut.
We'll keep working on UCI on that.
Thanks.
But as a public institution, they have their limitations on what they can do on that regard. Perfect. All right. Well, great comments. Sara, do we want to ask some questions? I see several coming in.
I have a few questions here that I'd be happy to mention right now. Okay, so the first is, what is the best way to prevent copying or intellectual property theft?
I mean,
you may want to take that.
Yeah, I guess I would say to file get your patents on file sooner than later. I don't personally know much about like cyber theft or things like that, but as far as getting your patent on file would be the best way.
Yeah. I have another thought. I mean, it's kind of a cockamamie thought, but maybe the best way that I think you can prevent abuse and copying and theft is the continual evolution of where your patent is, and that goes part of your IP strategy. For example, going back to the other point, let's say the university had the next generation of that kind of technology. You want to have that access either through right of first refusal or by your own development. So think about where Intel is. Intel always plans 2 generations ahead. People know where they're going, what they're going to do, but AMD can't keep up. So AMD has taken another approach, going after more of the graphics, same with NVIDIA. So the point is, the way you can prevent copyright infringement or abuse is continually to develop new copyright, new patents, new technologies, and keep them off guard. And that also goes back to the other point I raised on sustainability, defensibility.
Sure.
Little different approach than the legal approach.
Yeah, and to your point earlier, David, on the different types of IP, every company is going to have a different IP strategy, and one type of IP may not fit all types of industries, right?
Point, Matt.
I agree with that too. Just to say that you might have a patent on the core idea, the thing that's easily defensible in court, but you might have kind of a constellation of trade secrets that allow you to practice what you do in the best way because you're the expert. And that's certainly the case for us.
In that case, your contract strategy, right, would be critical to preserving that trade secret.
That's right.
Perfect. All right, Sara, let's do a couple more maybe while we're at it.
Okay. So if I've disclosed a software, like a beta version, Invention via a concept demo video on a website, is that considered premature publishing?
I'm not a lawyer. Maybe I'm the best to answer.
Yeah, I would think that's a question for you, Matt.
Yeah, probably. I mean, if a lot of people think they can hide like a website by using a publicly available link that's a random set of digits, and that's actually accessible. So I think the default you should think about is that if there's a disclosure, and that would be public accessibility would be the standard, if the public could access it without any limitation, then that potentially could prevent you from getting a patent. Now, certainly in Europe does not have a grace period. In the United States, we have a 1-year grace period, but I always see that as a fix and not a strategy because US is somewhat unique in that regard. Most countries, in fact, pretty much all the other ones that you'd want to file in do not have any leeway to allow you to file a patent after you publish. So most industries, especially life sciences, US might be the most important, but it's certainly not the only one. And Europe and Asia is quickly catching up. So in this setting, I would assume that if you do that, it would be a disclosure. But of course, there's always nuances that you'd have to look into.
Can I add or ask?
Sorry, go ahead.
That's assuming that the thing that is put on the website allows someone skilled in the art to invent or practice or infer.
Exactly. to make
Oh,
and
if
use
it's
whatever
not
the
doing
invention
that,
is.
that's probably okay.
That's right. That's right. So just as your patent has to be enabling, whatever is alleged to anticipate your later filed patent also has to be enabling for what you're filing on, for sure. But then it might be an obviousness issue, right? If it's not quite there but close. But yeah, that's right. There's certainly worth looking into.
Okay,
And then we have go ahead, Sarah. I think we have a question for UCI, right?
there are just some additional questions regarding collaboration with UCI. I would just encourage folks with those questions to reach out to Casie directly.
Yeah, good call. I'm sure they'd be happy to speak. So I think we have a few more minutes, and we touched on number 2, failing to control IP. And I thought David Cuccia hit it on the head earlier by establishing not only clear understanding between the company and the university on university IP that you could license, company IP, and joint in the middle, but also your collaborative process. I can't emphasize how helpful that is, advising companies to have the tech transfer office and the PI and the faculty members all in alignment with the company. But let's turn to the last one, because I don't want to lose time on that. So conducting insufficient IP diligence, certainly from our perspective, is probably the most important pitfall that one can fall into, and that would include both patent coverage, ownership, and freedom to operate. And I'll just toss it up. Does anybody? We've touched on a lot of these topics already. Does anybody want to discuss any further points on the importance of IP diligence?
Yeah, can I weigh in, because this is something that goes, it's really kind of the other side of the coin. One of the things that we're concerned about, and certainly all the issues that we talked about before, like the impact on the financials of your royalties or licensing agreement, making sure it's not just patents, but it's the whole portfolio of IP. But the issue that I want to raise for a lot of the entrepreneurs is to understand your risks and the impact. There's an acronym called PESTLE: political, economic, societal, technological, environmental, and legal, regulatory. These are risk elements. Those elements may affect the patent portfolio and how we look at the risk of investing in a company. For example, let's say the government decides that this kind of technology now has to be open to the world. Well, if that's coming down the line, your patent portfolio is kind of whacked out of kilter, your asset value is not as high. What happens if you have a new technology coming in? Instead of you had go back with the quote Negroponte switch from wire to wireless, where you change the bandwidth. All of a sudden now technology is replacing the patents that were available in the wireline market with wireless. Take a look at where Qualcomm is. Who else is competing? So it's like Wayne Gretzky said, think about the risk elements of where you're going and go to that point, not where you are today. So you have to look at your political, your competitive risk, your technological risk, your regulatory risk, your economic risk. And the economic risk includes things that may not be as good, but acceptable relative to the cost. So a risk impact analysis is something that I'm starting to look at when we look at investable deals.
Well put, and very, very well put. And all in connection with IP needs to work in order for the business to take off. Yeah, a patent on a standard that nobody uses anymore isn't worth very much, right? So yeah, very good points. Any further last comments? We're about 5 minutes to the top of the hour.
Yeah,
I also want to add one thing, just a quickie as a plug for you guys. Use the patent attorneys to help you out, get the strategy, and make sure they're involved early on. It's worth the effort, especially if you're relying on your IP to build your business. So that was a shameless plug for you, because
we appreciate that.
Meeting.
Thank you, David.
And Sarah's a UCI grad, so call her.
Yeah, there actually was a question whether or not there are free legal services provided to startups of UCI. As a plug for the law school, of which I'm also a graduate at UCI, there are clinics that are pro bono if you're a startup, you know, pre-revenue and need help. So look out for those.
Thanks, Sarah. Thanks, Matt. I'd also say that the SBDC has relationships with a lot of law firms in the region and a startup kit that offers our clients reduced rates and usually free consultations. So in addition to Wilson Sonsini's fabulous support, there are lots of law firms in the area that support startups. Well, I just want to thank our panel so much for today, Matt, Sarah, all the support from Wilson Sonsini, our panelists, David, the other David, Casie, and Kathy. I just want to make sure that everyone knows you'll all receive the recording and slides tomorrow via email. If you need immediate assistance with loans or funding or IP, please call our hotline number, 1-800-616-7232. And to get no-cost one-on-one consulting on your tech or life science business, please go to sbdctech.org/contact, and we'll pair you with a consultant for your needs. If you have any other questions, please email hkhaled@fullerton.edu or anyone that's listed here on the screen. All of us are here to help you and your business start, grow, and succeed. So thanks so much for joining us, and stay safe and healthy. Thanks, Sarah. Thanks, Matt.
Thanks,
Thank
Terry.
you.
Yeah.
Thank you all. Bye-bye.
Thank you.
Thanks.
Bye.
Yeah.